All rise. The Court of Appeal in and for the State of California, 5th Appellate District is now in session.
Thank you. Please be seated. Good morning once again. Calling the first matter, People versus Tyrell Collins. Please state your appearances.
Michael Sampson, for Appellate Tyrell Collins.
And you've requested 15 minutes. Did you wish to reserve some portion of that time?
I'd like to reserve 3 minutes, Your Honor.
Okay, I will watch the clock, and you can as well, and I'll try to remind you.
Thank you.
Thank you.
Good morning, Your Honor. Harry Joseph Colombo, Deputy Attorney General for the People.
And you've requested 15 minutes as well.
Correct.
Thank you very much. We are very familiar with this case. Have reviewed the briefs in their entirety, and would just ask that you keep that in mind during your argument. Please proceed.
May it please the Court. The primary issue in this case is whether the search of Mr. Collins's car was constitutional under the inventory search exception to the warrant requirement. The United States Supreme Court has long held that inventory searches are constitutional when the prosecutor proves 3 things. First, that the impound of the car was reasonable. Second, that the inventory search was conducted pursuant to standardized police procedures. And third, that the officer who conducted the search of the car was not motivated by a desire to investigate criminal activity.
Let's take that first one. With respect to the impound being reasonable, are you contending that it was not a reasonable impound of the vehicle in that particular neighborhood?
Yes, Your Honor. We're more specifically, we're contending that there is no evidence regarding why the police officers in this case decided to impound the car.
Now, was it a high crime area?
Officer Hernandez, actually both officers in this case, testified that this was a high crime area. Officer Hernandez specifically, she clarified that and testified that the area was known for narcotics sales. However, she never connected the high crime area with the decision to impound the car. In other words,
Do you have to make that actual connection, or if in fact at the time of trial or during that particular hearing, they note that it's a high crime area and the vehicle was impounded? Do you have to actually say, and that is why we did what we did, or can you look at the totality of the evidence?
Your Honor, the officer at the suppression hearing must testify as to her reason for, or his reason for impounding the car. And that's the Williams case and the Torres case cited in the briefs. There must be some evidence in the record regarding why the officer impounded the car. And the reason is generally in Fourth Amendment cases, we look to objective factors and overall reasonableness. However, in the inventory search context, the courts look to the subjective intent of the officers who decided to impound the car and decided to search the car. And so what the courts say in the the Williams and Torres case is that there must be some evidence in the record regarding why the officer decided to impound the car. And that reason must be reasonable in that it must further some community caretaking function.
Now, the officer indicated here that there were certain furtive gestures at one point when, in fact, that officer was going back to the car. The person in the front seat was making some gestures toward the floorboard and looking back to see, at least in that officer's opinion, perhaps if he was being viewed. Would that be enough to raise some suspicion that maybe a search or a search incident to that ultimate arrest would be reasonable?
It may, Your Honor. The search into to arrest rule, in this case, Mr. Collins had been restrained in the back of the police car at the time the search was conducted. So under the United States Supreme Court opinion in Gant, the officers were allowed to search the car under the search incident to arrest exception to the warrant requirement to look for evidence of the crime of arrest. Here, Mr. Collins was arrested on outstanding misdemeanor traffic warrants. He was also pulled over for not wearing a seatbelt and having tinted windows. So the question would be whether the officers had reason to believe they would find some evidence in the car to related to those offenses. And in this case, there wouldn't be any evidence in the car of driving offenses. And going back to to Your Honor's question about the furtive gestures and looking back, the prosecutor in this case never argued or never sought to justify the search on the grounds of probable cause. The issue was never litigated below. The trial court did not make any findings regarding probable cause. The trial court did mention in its holding, as far as the reasonableness of the seizure and the arrest, the court mentioned the high crime area and also mentioned the furtive gestures and the movements and said that evidence may rise to the level of reasonable suspicion. However, the court did not make that finding because it wasn't necessary. So it is our position that there would not have been probable cause in this case to search Mr. Collins' car based on the evidence that was presented at the suppression hearing.
Counsel, there was evidence that the car, or in the record, there was evidence that the car was in a high crime area. The defendant was being arrested for not having a valid driver's license, so he wasn't going to be able to drive the car away. There was no evidence of anybody else being present to drive the car away. Did the officer need to spell that out, or can we just look at the record and say, why would they leave the car there?
Your Honor, I would say that the officer would at least have to explain why she decided to impound the car. And the facts here are similar to the facts in the Williams case, where the driver was arrested and the officer argued, or essentially the people argued on appeal, that the officer had authority to impound the car under the vehicle code. And the driver in that case, like this case, was arrested. And what the court said is there still has to be a showing of why the car was impounded. In that case said the officer could have testified it was in that there was in an area where the officer believed it might be vandalized or stolen, or it was blocking a driveway or a street, something of that matter.
So that can't be inferred from the record. That has to be directly articulated by the arresting officer or the searching officer.
Yes, Your Honor, and that's essentially the holding of the Torres and Williams case, that there must be an affirmative showing. The trial court cannot assume that the decision to impound the car was reasonable simply because the officer had statutory authority to do so.
The court did, looking at all the evidence, indicate on the record that he did not see any pretext, at least in the evidence that was presented to the court, for why they wanted that inventory search. Is that correct?
Correct, Your Honor. Yes, the trial court said that this was a valid inventory search and found that it was not pretextual in any way. And
do you think it was? And if so, was there any evidence of that?
yes, Your Honor, I think that the primary reason for searching Mr. Collins' car was to look for evidence of a crime, and the evidence to support that would be Officer Hernandez's testimony. She was asked on direct examination at the suppression motion, why did you search this car? And she said, I did so for two reasons. First, I was suspicious that there was evidence of essentially contraband in the car, and I wanted to search the car to look for it. And second, I had to conduct an inventory search. So I think Officer Hernandez's testimony shows that her motivation in searching this car was to look for evidence of a crime.
Now, if you have two reasons, can you have two reasons, one of which might not be the best reason, but another a valid reason? Or does the fact that you have both of those somehow, in your opinion, negate the other?
Your Honor, it does negate the other. And as far back as the Bertine case, United States Supreme Court case in Bertine, the court held that inventory searches are not subject to the warrant requirement, specifically because they are totally divorced from criminal investigation. In other words, the officer searching the car under an inventory search is simply marking down the items, the personal property of the suspect. Nowhere in the officer's mind is a criminal investigation present. And cases like Aguilar in the briefs, and I believe Torres, say that the the officer it must be their only intent is to conduct an inventory search. If they also intend to search for evidence of crime while they're doing the inventory search, that does negate the validity of the inventory search.
So if you have two reasons, and let's say that the officer made no mention at all of just liking to do inventory searches, but just stopped with the first reason, are you saying that, in fact, that would have been a valid search?
If she said it was just to, I just want to understand your question. Yeah. If the first reason, if she only said, I wanted to look for evidence of a crime?
Based on what
Based
she
on what?
observed the person in the front seat doing, yes.
I think that would be a different issue, Your Honor. I think that would be more of a probable cause analysis. And again, the prosecutor below never sought to justify the search on the basis of probable cause. That issue was not litigated. It was not before the court. If she had only said that first part and the prosecutor still sought to justify the search as an inventory search, I think the result would be the same.
But if you have a high crime area and you have a person in the front seat making furtive gestures in between the seats, looking down, looking back at the police, would that alone not be enough?
That would not be enough for probable cause. It would also not be enough for an inventory search. The prosecutor sought to justify this as an inventory search. So if Officer Hernandez testified, I searched this car because it was in a high crime area and I thought Mr. Collins was committing a crime, that does negate the inventory search. That turns it into something else. It turns it into a search for evidence of a crime, which must be supported by either a warrant or probable cause, neither of which we have in this case. And so if I get to the second issue, which was the inventory search itself, the Supreme Court has long held that inventory searches must be made pursuant to standardized police procedures. And in this case, there was no mention of any, that Bakersfield Police Department had any standardized procedures regarding inventory searches. Officer Hernandez never testified that there were such procedures, neither did Officer Garcia. And every court has held, back to Opperman and Bertine, that all inventory searches must be conducted pursuant to standardized police procedures. And without evidence that Bakersfield Police Department even has such procedures, the trial court could not have held that those standards were constitutional. And so for that reason, additionally, the search was unconstitutional. Also, the Wallace court held that perhaps the best way to show that this was an inventory search would have been for the prosecutor to actually introduce the inventory, the completed inventory, at the suppression hearing. In this case, the prosecutor did not introduce any inventory. Officer Hernandez and Officer Garcia did not testify that they completed inventory. They, in fact, did not testify that they even started an inventory. And so what the Wallace court says is that when no inventory is actually produced, the inference is that this was not an inventory search. If Officer Hernandez was doing an inventory search and happened to find contraband, there's no reason that she would not have continued to finish the inventory search if that is what the purpose of the search was. And again, we have no evidence in this case that an inventory search was ever completed. And so since this case has no standardized procedures in the record, because Officer Hernandez specifically testified that she was motivated by desire to investigate criminal activity, the search was unconstitutional. The trial court abused its discretion in not suppressing the evidence, and this court should reverse appellant's convictions. Unless there's any questions, I would like to reserve the rest of my time.
Time will be reserved, and thank you very much. Counsel.
Good morning. May it please the court. I would initially like to take issue with appellant's contention that the primary issue that was presented at the suppression hearing in this particular case involved the propriety of the inventory search. That is not, in fact, what the record reflects. The record reflects, quite the contrary, that the prosecutor's theory of this case was that the search was justified initially incident to the defendant's arrest and alternatively based upon probable cause as a result of the officer's observations of the defendant's conduct after the vehicle had been pulled over. And while one officer was checking on the validity of the defendant's license status, the other officer observed him to be manipulating something that she described as some kind of object between the center console and the plastic area over the carpeting within the vehicle. This inventory search question only came up after the prosecutor asked Officer Hernandez, "Why did you conduct this search?" And she said quite candidly, "I conducted the search because, first, I suspected there could be evidence of either contraband or something else that was in the area that I had seen the defendant putting his hands down between the console and the carpeting area in the vehicle, as she described it, where people don't ordinarily put things." And she testified without contradiction, she watched this happen. This wasn't something that she was speculating about or conjecturing about. She actually saw the defendant's movements. Then she said, in addition to which, because we were going to impound the vehicle, we're required to conduct an inventory. And since this was a high crime area, there's a concern that these vehicles could be tampered with, vandalized, stolen, objects within the vehicle taken. So
Did you
it's,
say that, or are you inferring that from the record?
I'm inferring that from the record and the fact that that's what the trial court concluded as a result of its listening to the testimony of both officers. There were two officers, Officer Garcia and Officer Hernandez. And I think it's important that we put this factual situation in context. Appellant's counsel wants this court to basically look only at what happened after his client was arrested and when the search was about to be commenced. It's important to look at what caused the officers in the first instance to undertake to stop and detain the defendant, and that was he wasn't wearing a seatbelt. The windows of his car were tinted dark to the point that the officers couldn't see within those windows. The officers testified, both of them. Upon seeing the defendant without his seatbelt on and with the windows tinted dark, they made a U-turn to commence an enforcement stop. As they did so, they watched as the defendant, the officers, Garcia described it as frantically trying to put on his seatbelt and rolling down the windows, indicative of behavior, I would submit, consciousness of guilt. He knew he was in violation of the law. Pulled over. The defendant didn't have a driver's license. He gave the officer his identification card. When the officer went to run the identification to see if it was valid, he discovered the defendant had a suspended license and 2 outstanding arrest warrants. So at that point, the officers undertook to take the defendant into custody to place him under arrest. So the prosecutor's initial theory at the suppression hearing, contrary to appellant's argument, is that the search was conducted incident to arrest. And there was a lot of testimony that was elicited from the officers about where was the defendant when the search was conducted. He was in custody. He had been handcuffed. He was placed in the backseat of a patrol car. Now, there's a long line of authority that discusses under what circumstances a search incident to arrest is lawful. Most recently, in Arizona versus Gant, the United States Supreme Court said a search incident to arrest of an automobile is only valid if the suspect is within proximity of the vehicle such that he could alter or manipulate, get to whatever's in the car the officers are searching for. Alternatively, then the prosecutor asked Officer Hernandez, okay, what was it about the defendant's movements within the car that you saw suggested there could be something in there that could either be contraband or evidence of a crime? And she described what she saw. Now, to sort of move ahead for just a little bit, there's no evidence in the suppression hearing record that the defendant was manipulating a cell phone, that he had dropped something in the car, that he was reaching down to pick it up.
Let's go to that evidence, because of course, he tried to get in evidence that in fact he was on a cell phone trying to inform someone that he was being stopped. Is that correct?
Yes.
And that particular evidence was excluded from consideration.
The only evidence that was excluded, Your Honor, was evidence of the cell phone records, because there was no way to correlate the time based on the records from the cell phone company and the time that the incident was occurring, because there's a conversion that has to be done, I understand.
But
between-
that was like a time zone conversion or something?
That's correct.
Which would seem to be fairly simple to do, at least in terms of a stipulation by counsel or some other form of agreement that, you know, if it says this particular time zone for that call, it really meant this for the place where the incident happened. So why would excluding that evidence not be important to the defendant to show, in fact, he was not doing anything untoward other than calling someone to let them know what was going on?
Well, I would submit that it's not sufficiently relevant to the question of what was he doing at the time that the officer saw him reach down into the area between the center console and the carpeting or plastic area underneath the driver's seat. The defendant's testimony was, I was on my cell phone and I'm texting to my friend, and my records would show that at the exact time that I was being stopped and detained, that record would show that I was on my phone. Okay, that's fine, but all that does is establish that he, in fact, may have sent a text message. That wasn't disputed. The prosecution didn't contend, oh, well, you didn't have your phone, you weren't making a cell call, you weren't sending a text message. The prosecutor argued, all that does is suggest that there could have been some alternative explanation for why the defendant had his hands in the vicinity of his lap. When the officer was testifying, she saw him moving something. He didn't drop something. He didn't drop his cell phone and have to pick it up. She said, I saw him put his hand down, put something in that area. I didn't know what it was, but it looked like some object. So the defendant's testimony wasn't, I dropped my cell phone and had to pick it up in order to complete my text message. His testimony was, I had it in my hand the whole time, on my lap, texting to my friend. So there was no dispute in the evidence, in the testimony of record, that he was either sending or receiving a text message. That wasn't the evidentiary dispute that the jury had to resolve. The dispute the jury had to resolve was he moving something into this area the officer testified she saw him putting something into, or was the officer simply mistaken that he was moving his hands in that way? That's why in my brief I've argued this was a pure credibility contest. The jury was either going to believe that the officer saw what she claimed she saw, or that she was wrong, and that the defendant was not in fact doing anything suspicious that would suggest that he was trying to hide evidence or he was trying to hide something from the police.
Are you trying to justify this as a search incident to arrest or a proper inventory search?
Well,
I'm a little confused.
I submit that the prosecutor at the trial court level sought to justify this as a search incident to arrest. But as the testimony developed, and I think the court, I can reference the pages in the reporter's transcript for the court's reference, and I'm sure the court's already read these pages probably several times. But the initial testimony of Officer Hernandez was, while she was waiting for Officer Garcia to do what he had to do to check the status of the defendant's license, she watched as he put his hands down into this area that she thought could have been contraband or something else. Officer Garcia comes back and says, hey, he's got an invalid license, it's suspended, he's also got 2 warrants, he's under arrest. They pull him out of the car, place him into custody. He goes then into the patrol car to wait while Officer Hernandez does the search. She initially says, I conducted this search because I had essentially a strong suspicion there was something there that he put down under that console that either could be evidence of a crime or contraband.
But would that be a proper search incident to arrest? No, he's out of the car.
No, that would be a probable cause search, and I'm glad the court asked that question. Appellant contends that the prosecutor never sought to justify this search as based on probable cause. I disagree. The testimony that was presented showed that the officer's basis for suspecting there was either contraband or evidence of a crime in the area where the defendant had put something between the center console and the carpet was because she believed, based upon what she had seen, that she was likely to find something there. And lo and behold, she did. She found a .38 caliber Smith & Wesson revolver. So even though the prosecutor, in fact, to be perfectly candid with the court, I'm somewhat disappointed as an appellate prosecutor that the trial prosecutor never even argued what her theory was to support the search. When presented with the opportunity to articulate for the trial court what her theory of the case was, she simply said, I submitted on the testimony. So whether that's sufficient to raise the issue for this court's consideration or not, I submit the court can determine for itself. But I think the evidence that was presented supports that theory or that argument, and I think it's a legitimate theory in this particular case. In fact, I think, quite honestly, that was the prosecutor's best argument. I wish she had made it in the trial court, but the fact that she doesn't disprove or fail to establish that that was a justification, as this court's well aware. The U.S. Supreme Court, California Supreme Court, this court, every appellate court has basically held that when the prosecution is presented with a motion to suppress, the defendant has to first establish a reasonable expectation of privacy in the place or person searched, and then the prosecution has to justify the reasonableness of the search. None of those cases ever hold that if the prosecutor doesn't specifically articulate what his or her theory is, he's foreclosed from arguing that on appeal, so long as there is evidence in the record that supports that theory.
What about the officers having to articulate a theory?
Well, the officer did articulate a theory. She said, I searched this car because I believed I was probably going to find something in that area where I'd seen the defendant move his hands. And I think it's important to understand, in the context of this case, when the officer's describing what she saw, she says specifically, I saw him reach down. He reached down, and then as soon as the other officer started to come back to the car, he immediately pops back up as if, well, I didn't do anything. I didn't put anything down there. So when we look at this in the entire context, now as I've written in my brief, and I agree, the courts have held a furtive movement in and of itself is insufficient to support probable cause. But we have more than that in this case. We have the defendant's behavior when he's first seen driving without his seatbelt on. He's frantically trying to put it on, rolling down the windows so the officers can't see that they're tinted dark. He's pulled over, hands over his identification card, says, I don't have a license. The officers find out it's because your license is suspended, okay? And you have 2 arrest warrants. So we have to look at this in context. While all of that's going on, the second officer is watching the defendant's behavior, and she sees exactly what he's doing, how he's doing it, and where he's doing it. So when we look at the totality of the evidence, not just parsing out individual components of the proof, I submit that this court can find that there was adequate evidence that this search is justifiable either as incident to arrest, as an inventory search, or pursuant to probable cause. Any of those 3 theories, I submit, would support the trial court's ruling in this case.
What about the argument that since there was no inventory search put into the record, any results of that kind of debunks the theory that this was really an inventory search?
Well, I submit that in this case, the officer gave uncontradicted testimony that it's her practice or procedure whenever they impound a vehicle to do an inventory search. Whether that's sufficient or not for this court is for it to decide. But I submit that on this record, without contradiction, it was satisfactory. Unless there's any further questions, we'll submit it.
Thank you very much, counsel.
I'd like to respond first to respondent's argument that the inventory search justification in this case was more of an after-the-fact justification that was brought up for the first time at the suppression hearing. Defense counsel in this case filed a motion to suppress. The prosecutor then filed an opposing motion and sought to justify the search on the single ground that this was an inventory search. It was a thorough brief with all the pertinent cases cited, and that was the only ground that the prosecutor sought to justify the search. As far as the incident to arrest, that actually first came up on cross-examination. So it was defense counsel that first asked whether this was incident to arrest. Officer Hernandez initially testified, no, it was not. It was an inventory search. The defense counsel then asked again, so it was for those two grounds, and Officer Hernandez said yes. It can be inferred that she was referring back to incident to arrest, but it's unclear whether Officer Hernandez ever sought to justify this as a search incident to arrest. I'd also like to address the fact that this court may determine whether the search was based on probable cause for the first time on appeal. Again, the prosecutor filed a motion in which it sought to justify the search as an inventory search. There was no one argued that this was based on probable cause in the trial court. The trial court made a single finding this was a valid inventory search. And the Torres case addressed a similar situation where the search was justified as an inventory search. And on appeal, the appellate court said, since the prosecutor never sought to justify this below as a search based on probable cause, we're not going to reach that issue on appeal. And I would argue that the same applies here, and that a probable cause determination, since it's an intensely fact-based inquiry, is more appropriately brought in the trial court. And the prosecutor here did not bring such a motion, never sought to justify the search on that ground. I'd also like to reply to the second issue in the brief, which was the judicial notice, quickly if I could. Respondent argues that the evidence was not relevant, essentially because it would not dispositively prove appellant's, Mr. Collins' innocence. The prosecutor below told the jury that if Mr. Collins was using his phone during the stop, then that would tend to discredit Officer Hernandez. And I do agree with the respondent that this was a classic credibility contest between Officer Hernandez and appellant. And evidence that he was on his phone would have corroborated his testimony while at the same time contradicting Officer Hernandez's. And under the Randall case, the courts find that that type of evidence is prejudicial. And unless the court has any questions, I would, in sum, this search was not based on standard procedures. And for that reason, this was not a valid inventory search, and this court should reverse Mr. Collins' convictions. Thank you.
Thank you very much, counsel. I'd like to thank both counsel for their excellent arguments, and also, once again, as we indicated before, for coming here in person to Kern County. We very much appreciate it. The matter will be submitted. I should note that we have a new panel of justices coming out. At the 5th District Court of Appeal, we have 10 justices rotating in random panels assigned to each case. So coming out in a few moments, we'll have Justices Pachigian, Meehan, and DeSantos. We'll be back in just a moment.
All rise.
Thank you. Please be seated. Well, on behalf of the second panel today, we welcome you and thank you for your participation. This is very exciting for us, as hopefully it's educational and maybe exciting for you as well. The second case that we'll call is People versus Mendoza. That's our case number F073360. The panel today is comprised of Justice Meehan, Justice DeSantos, and myself, Justice Pachigian, and our counsel ready.
Good morning, Your Honor. I'm Christine Bento for Mr. Mendoza.
Thank you.
Jennifer Alexa on behalf of the Attorney General's office.
Thank you very much. We are familiar with the facts of the case and have certainly are also familiar with your arguments through your briefing, and we look forward to hearing your presentations.
Good morning, Your Honor.
You reserve 15 minutes each.
Yes, please, and I'll have 3 minutes out of that for a rebuttal.
That'd be fine.
Thank you. Appellant has argued that there is no substantial evidence of aspiratation to make this crime an aggravated robbery because appellant's movement of the victim into a well-lit store from the gas pumps on a late evening night in January was incidental to the robbery. He's trying to get the money from the ATM. And it did not increase the risk of harm because it was well lit inside the gas station. There were patrons, there was a surveillance video, and there was a clerk. As the court knows, there are 2 prongs to kidnapping for robbery. The aspiratation must not be merely incidental. And the second is it must increase the risk of harm over the victim. As I said, the prosecution has not met the first prong. First of all, there is a case that says that in a service station environment, the pumps can be considered part of the service station as well as the store, so it's all one location. That makes sense. Chevron doesn't certainly think its pumps are different from what's in the convenience store. So it makes sense that this is all one location, and that's a factor.
That's not dispositive, though, is it, counsel?
No, not exactly, Your Honor. The most dispositive aspect is the harm.
But staying on the point that you're making, in addressing the cases that were cited in the briefs, perhaps it would assist the court if you could address the issue of whether you lend any significance to the fact that, for example, in the Williams and Washington cases that were cited, the victims were all employees on duty within the building or premises of their employer. And just as you're making your statement, if you would address that, it would be appreciated.
Yes, Your Honor, you're right. They are employees, but it's really, and as I said, the location and the harm aspect are all part of the interrelated aspect of this issue. They're definitely interrelated. I don't think an employee versus a non-employee, like the victim here, is any different as far as harm goes. If a person...
In terms of what they're doing, they're performing their job duties inside the building, and the perpetrator needs to move them so that they're out of the way so that they can conduct the robbery. And I'm just wondering if those circumstances are significant to you in distinguishing them from the circumstances in this case.
Exactly, Your Honor. And I would say that no, there is no difference because the defendant has to get the money in either of these cases. And whatever he has to do to get the money, he's going to do. And in my case, he wanted the money from the ATM. So he had to get the victim to the ATM. The robbers in those other cases wanted items in the store. They had to take the victims into a vault, which definitely looks like there could be more harm involved in going into a vault than there would be going into a convenience store. So I certainly understand Your Honor's point, but I really think the focus is not on the status of the victim, whether it's an employee or not.
Counsel?
Right.
Yes.
I'm sorry.
Sorry.
Counsel, is there significance to the fact that that the victim, when he was outside the store, may have had an opportunity to escape, whereas taken at gunpoint inside the store may not have had that same opportunity, that the harm is greater when he was confined inside the store versus out in the open?
Yeah, I understand Your Honor's position. I don't think so, Your Honor. I think, you know, if it's these pumps at these gas stations, this is late at night in January, these pumps have limited lighting, you know, right by them, and you start running away, there is a possibility that you could be shot at. I think running away from a gun is not necessarily the safest thing to do. I think the safer thing to do, and well, he was safer inside this well-lit store. He was safer when Mr. Mercado knew there were at least 3 people watching this going on. And maybe Mr. Mercado didn't know surveillance videos, but more than likely he did. I think people have picked up on the notion that all of these facilities have surveillance videos. So I think the chance, as I detailed, I think the chance of decreased likelihood of detection, inherent danger in the victim's foreseeable attempts, attackers' enhanced ability to commit additional crimes, these were all gone once he went inside that store. They were all gone. In fact, I believe that more detection was likely because everyone saw this. The 3 people in the store, and there was a surveillance video. I think Mercado wasn't going to do anything. He would just walk away. If things looked like they weren't going to be happening the way he had planned, the defendant would have just left. I don't think he would have raised a fuss. Nothing would have happened. Yes, Your Honor.
The issue of the likelihood of detection and harm are two distinct issues, aren't they?
They're all aspects of it, Your Honor. That's the way it's phrased in the case law. They talk about it as the second prong of the test for aspiratation. Includes consideration of the following factors. 1, decreased likelihood of detection. The danger inherent in a victim's foreseeable attempts to escape. The attacker's enhanced opportunities to commit additional crimes. And the possible enhancement of danger to the victim resulting from the movement. So it's all one unit, Your Honor. And you can't just separate them out. You have to consider it as one. And I don't think, as I said, with everything that was going on inside that store, the lights, the people, the surveillance, it was not possible for this to be more harmful than out in the pumps. If the court has no further questions, I have 2 issues in this case, if you don't
Please.
mind.
Yes.
Couldn't the
Sure.
perpetrator have committed additional crimes inside the store by perhaps robbing the store owner or the store owner or manager getting involved somehow?
You know, Your Honor, you raise a good point. You know, the trouble is, I think that's kind of, I hate to say it, not really, it's more speculative, I think. I mean, again, you could say, well, there's a chance of that, and you're correct, Your Honor, but there's also an equally valid chance that he's just walking away if he sees things not working out, that he's not going to push this. If Mercado doesn't want to give him the money, he's just, you know, I mean, the gun I don't think is really visible at this point inside the store, although the victim knows he has it. Yeah, the victim, Mercado, knows he has it. Your Honors, do you have any further questions? Can I go on? Okay, thank you. This is a 654 argument. This is a different victim. These people, you know, he's there, might as well do something else. Mr. Arvizo went to this gas station to get food because there was a food truck there. But he's standing there, and the defendant walks up to him and wants his money from the ATM. And so he's convicted of 2 crimes for this. One is a secondary robbery of the keys, and I'll explain that in a minute. And the second is the attempted first-degree robbery of the ATM because he didn't get the money. So under this rule that they have in California law, you can be convicted of a lot of crimes, but you can't be punished when it's an individual course of conduct. The courts have said that. They don't want to double, triple punish you for the same intent, the same individual course of conduct with a single objective. And I argued that the only objective the defendant had was to get the money from the ATM. It's the same objective he had in the first crime. And it was an indivisible course of conduct because he took Mr. Arvizo's keys. he said, well, give me your keys. At one point, give me your keys. And then, because Mr. Arvizo agreed to go up and get money at the ATM all by himself, and the defendant was going to stay by his vehicle. And he took the keys, and Mr. Arvizo understood that to mean that, quote, he told me to give him the keys so that I would come back from the ATM. And the prosecutor at trial agreed with that scenario. In closing argument, he said, quote, the defendant took his keys and implied that he would get them back when he came back from the ATM. So the only reason he took the keys, which was the basis of one of the counts, the secondary robbery, actually taking the car keys, was so that the guy would come back with the money, which was the basis of the second count, which is attempting to take money from the ATM.
Could there have been a secondary objective of having a means of escape? Could he not return?
Your Honor, that was brought up, and that's a good point. That was brought up in the briefing, and Mr. Mendoza went to this location. He was not from the Bakersfield area. His father owns a ranch in the area, and he went out for a night of fun with one of the employees of his father at this ranch. And the employee, the car, and he had money, and they were going to have a good time. I just don't think, even though it is a little ambiguous, where is the Camino or El Camino at this point, I don't think the employee of the defendant's father would have deserted the defendant. I don't think the father would like that if he heard about it. So the location of the El Camino, he's going to get back in that car if he could, obviously, if the police hadn't come so quickly. I don't think that the...
But if the El Camino was gone, which it was when he...
Well, I don't know...
Then he had access to the second vehicle.
Well,
right?
I don't know that it's actually gone, Your Honor. I think maybe it's just out of people's view. There's no clear... Again, I don't think the guy would have deserted him, is what I'm saying, because...
According to the defendant, when he testified, he went looking for it right away when he heard the police coming down.
Right.
Because it wasn't there.
Right. That's true, but not in the immediate vicinity, but possibly coming around to pick him up later to see what was going to happen with the police. Were they going to find the defendant? If not, he was going to circle around. I mean, the defendant was not going to be able to get in any car necessarily once the police came, whether it's Mr. Arvizo's or the other gentleman's, yeah. And that was pretty evident. And again, as I said, this is an indivisible course of conduct with a single intent. He just wants the money. And, cases have said that in analogous contexts, for example, when arson is the means by which a perpetrator attempts to kill, 654 precludes punishment. If a defendant assaults a victim in order to carry out in order to carry out a robbery, he can only suffer one punishment. A court has held that commission of assault with a deadly weapon, which was used to accomplish a carjacking, can't be separately punished. These are more serious in a way than the crimes today that we're talking about, and they would not allow double punishment on those crimes. They facilitated one crime, just facilitated the other. It was not independent of it.
Counsel, you're down to about two and a half minutes.
Should I reserve then?
It's up to you. That's your call.
Well, I just had one aspect, which is that when you rob somebody of various items, cases have held, it's one robbery. And this is not exactly, because we have an attempt here, but it's just one robbery.
Excuse me, we asked you a lot of questions, so if you need a little bit more time to develop that, that's fine.
Well, that's very nice, Your Honor, but I'll keep this very short, because I don't really know that the respondent really addressed this issue, and maybe he felt, there was a reason not to. But I point out that when the defendant robs a victim in one continuous transaction of several items of property, punishment for robbery is there's only one robbery. You don't get punished for each individual item that you robbed. For example, in Dominguez, the defendant entered a van, put a weapon to the driver's neck, and demanded everything that the driver had. The victim gave the defendant jewelry, then fled on foot, and then the victim's car was missing. But the court found 654 barred punishment for both robbery and carjacking. And in Bauer, defendant entered a home of a woman, 3 women under false pretense, and subdued them, bound them, moved items of property. He got concurrent sentences for robbery and car theft, 654 barred punishment for both. Anyway, don't want to keep your honors. Thank you so much.
Thanks very much for your presentation, Ms. Vento.
May it please the court. With respect to the first issue, I'm just going to dive right in. As far as appellant's characterization of the environment that the victim was found in, the first victim, Mr. Mercado, while he was parked at the furthest gas pump, and it is on the surveillance video, it is difficult to see them. You can see a little bit of activity over there, but you can't see what occurs over there. However, the gas station itself is as well lit as inside the convenience store. There's bright lights overlooking all of the pumps, and it's also, I would like to point out, near what looks to be a very busy street. We pointed this out in briefing. If you watch the surveillance videos, there's almost a constant stream of traffic going by both ways, and cars pulling in and out of the gas station, other patrons. In my view, that enhances the risk, or not the risk, I'm sorry, enhances the ability for somebody else to detect what's going on. And by moving Mr. Mercado from the gas station parking lot into the convenience store, he is now surrounded by less people, still a few, the clerk and a couple other patrons are in there. However, there's not a regular flow of people around him, and while it is under surveillance and it is well lit, the same can be said about the parking lot. To me, that doesn't make any kind of material difference. With respect to the cases that appellant cites about, like you pointed out, Justice Meehan, the employees in their place of business, in People v. Washington, and a couple of the other cases refer to this quote as well, is that the rule to be derived is that the robbery of a business owner or employee includes the risk of movement to have access to the valuables of that business that are sought to be taken. So while appellant uses those cases to say that moving Mr. Mercado from the gas station pump to inside the convenience store are all part of the same premises, that to me is very distinguishable, that he's not an employee. If you apply that logic to this case, then there's almost never going to be a case where robbing somebody by bringing them to an ATM is a kidnapping for robbery. And most of the cases we see are, you know, a lot of them are a lot more severe in nature, and sometimes it's a little easier to maybe see why it's a kidnapping.
Had the ATM been outside the store, would that have made any difference whether or not there's aspiration from the pump to the outside of the building?
I believe it would
Still?
make a difference. Not in my favor, because at that point, he is still outside, he's still surrounded by more people. At the time he enters the convenience store, he is now surrounded by only a couple people, which the clerk testified that she did see appellant and Mr. Mercado enter the store.
So the doorway itself makes a difference in that particular case.
It does.
But the cases in, I believe Williams or not, says pumps and the interior of the store should all be considered as one, doesn't it?
It does say that, however, as I said, in that case, in Williams, we're dealing with, again, an employee who's moved. And so for that purpose, it goes back to this rationale that if you're going to rob a business owner or employee, there's a risk inherent in that robbery that you're going to move the employees. Whereas when you're dealing with just a person somewhere, anywhere, if you apply that logic to this situation, then there's almost never going to be a scenario where you have a kidnapping for robbery, because the fact that the goal is to get the money from the ATM is, you know, that is the goal. However, it's not necessary to, in this case, it was not necessary for him to move the victim. For example, while this charge was dismissed, but he did successfully take money from him in the parking lot. He had his motorcycle, he had a bag with apparently a lot of stuff on him. He easily could have robbed him in the parking lot, or could have taken his debit card and asked for the PIN and gone to the ATM himself.
Didn't he get the $20 initially and then got 40 more from the ATM?
There was some conflicting testimony. The testimony was that he initially got $20 from him and then had tried to withdraw $60, and there were insufficient funds. Rough day. And so he ended up pulling out $40 instead. However, there was a receipt found that said he had pulled out $60 from the ATM, so I don't know if that was his initial attempt or what. But according to the victim's testimony, he did take $20 from him in the parking lot initially. If there are no further questions on argument 1, I'm happy to move on to argument 2. The 654 issue, appellant counsel pointed out the Dominguez case, and in that case, the victim was sitting in his car. The defendant got into the car, put a gun to his, or what he felt was a gun, on the back of his neck, and said, "Give me everything you have. Give me all of your valuables." That's not what happened in this case. He displayed the gun to Mr. Arvizu and said, "Give me money. I need money, or I'm going to shoot up your truck." And when Mr. Arvizu said he didn't have any money, he said, "Okay, we're going to go to the ATM." He said he has money on his debit card. He's already in the process of complying. He's on his way out of his truck to go into the ATM to get appellant money. And at that point, he grabs the keys from him. To me, there's a period of reflection there, and the fact that he didn't initially ask for, all of the belongings, that's significant. This was an afterthought. This was something separate, potentially for a means of escape, because the car that he came in he didn't know where it was. And while there are other scenarios that appellant pointed out, such as that, his friend isn't going to leave him high and dry while he's robbing somebody, the fact that the record can, be reconciled with other outcomes is not the standard. The trial court found that there were separate acts, and if there's substantial evidence in the record to support that, then it should be upheld on appeal. And it's my contention that because there was a break, between his initial asking for money and then taking the keys, and that the victim was already complying with his demands, that shows that there are separate criminal intents. And I know I have a decent amount of time left, but unless there are any questions, I'm ready to submit on the briefing.
There don't appear to be any additional questions. Thank you very much. Counsel, you have just a little bit over a minute.
Thank you, Your Honors. I just want to say I don't have any evidence that there were a lot of people driving around on this street at the time. This is the first incident, so that he could feel safer. I don't know of any surveillance video at the pumps. I don't know that. So those are two items that were brought up that I don't know if those exist. I don't recall that ever being shown in the record. And that's all I'll say on on Mr. Mercado's, the victim, Mr. Mercado. On the second issue, all I can say is the victim and the prosecutor both thought that he was giving him the keys as collateral to make sure he came back from that ATM. They both thought that. How could two separate people, the prosecutor in the case and the victim, think one way, and yet we give Mr. Mendoza a different attitude? I don't think so. And also, I would just quote a phrase that happens in some cases. Your Honors would probably know this. Appellate courts should not parse the objectives too finely. So we would ask the court if they could consider that as well. Thank you so much.
Thank you very much. We appreciate your presentations, both the appellant side and the respondent side, and you will be hearing from us shortly, the matters deemed submitted. And we're going to take a short recess, and that'll give the participants in the audience an opportunity to interact with the justices in a Q&A. Thank you.